The lower left-hand corner of your screen is a pod called Files. These are downloadable files that are available to you during the presentation. The first is a copy of the slides, and the second is a supporting document that our presenter wrote for TMLT a year or so ago. The second pod on the bottom of the screen, the Q&A pod, is an opportunity for you to type a question during the presentation that will be answered at the conclusion of the presentation. I'm Kathy Bryant, and I'm with TMLT, and I'm hosting the webinar today. Just as a reminder, the information and opinions that are presented in this presentation and the supplemental materials are as is and are not to be used or referred to as a primary legal resource. It is my pleasure today to introduce our speaker, Adrian Senyszyn. Adrian is an attorney with the firm of Mahaffey Weber in San Antonio. Adrian has been involved in the cybersecurity world for many years and has been defending TMLT policyholders and helping them mitigate after they've had breaches or other security incidents. At this time, I'm going to turn the presentation over to Adrian and welcome him to our webinar.
Thank you very much, Kathy. Just a quick check. Can you hear me okay? It appears that my microphone's working perfectly, correct?
Yes, seems that way.
Perfect. Well, first I want to thank Kathy and TMLT for asking me to present. I've been defending TMLT insureds before the Office of Civil Rights and the Texas Medical Board with regard to HIPAA issues for many years now. And I'm really going to speak to you about the lessons we've learned in terms of our defense and some of the real key features we've identified that we need to do whenever we have a breach. And some of this is guideline driven by the OCR, and a lot of it is past years of experience that we put together. And I think the most logical way to start is by presenting a hypothetical situation. And what you're seeing here is a hypothetical scenario that we're going to work through today. And this is actually a note that I've reproduced from another case and modified it. But this would be a piece of evidence that we would use in an actual case. And it was an IT log note after a cyber attack. And as you can see, our hypothetical attack hasn't yet occurred, but it's going to occur next Monday morning when the employees from the office walk in and they try to turn on their computers. And the note goes by saying, I was informed that the computers are running extremely slow. I checked the server and saw a person by the name of Gary logged into the server. I checked with our EMR guys, Chris and Tom, both denied knowing Gary. I immediately shut down the server. So this is the IT person writing this after they've been contacted. About 30 minutes later, there's another note and it says, around this time, the IP technology sent their engineer, Ryan, who started analysis on the security. He disconnected us from the internet completely. With the server down, we cannot access any EHR files. I backed up the PP backup folder, which contains our daily Metasoft EMR file backups, and took it home and kept it safe. Later that morning, we see a note that they've now identified the source of the problem, and it's a ransomware virus that's encrypted their files and their Metasoft EMR. Obviously, this could go two ways. You could have a cloud-based EMR system where you're having your computer systems encrypted where you can't reach your cloud-based EHR or EMR, or you can have your EMR on your server and have it locked up. And then last, we have a ransom for $5,200, and there's no way for them to obtain a decryption key, so the practice at this point is stuck with this ransomware on its server, but they also have the possibility of wiping their servers and completely rebuilding the system within 24 to 48 hours. So let's just talk real briefly. The legal framework that we're working with when we're looking at a HIPAA incident and a cyber attack is the HIPAA code itself, and that's the first code listed there. But you should be aware that there are other codes. So the Federal Trade Commission Act has a code, and it's a HIPAA gap filler, and this would fill entities and organizations that don't necessarily fall within the square rule of the HIPAA Act itself. And there's a notification process in the Federal Trade Commission Act. Federal Trade Commission Act also deals with financial issues. So if a practice is affected and your financial information is impacted, you may have an obligation under the Federal Trade Commission Act. There's also the Texas Identity Theft Enforcement and Protection Act, and this is a Texas statute that applies to computerized data that's in your possession, and it would require you to notify patients or individuals whose sensitive information is in your possession that was impacted by some sort of ransomware or other virus or some kind of breach. It follows very closely with the reporting requirements under HIPAA. So if you are meeting your breach reporting requirements under HIPAA, you're meeting your Identity Theft Enforcement Protection Act obligations as well. And then lastly, you have to be aware that if your patient or person affected is a resident of a different state, each state has different obligations, and you might have to follow those particular obligations of a different state while giving notification and complying with your federal requirements under HIPAA. So a breach is very definitional based, and it's the acquisition, access, use, or disclosure of protected health information in a manner not permitted. The real key is protected health information is information that can be re-identified with the patient. So we need to have some sort of patient identifier, whether it's a name, a patient identification code, some demographic information, and we need that information to be re-identified with some sort of healthcare information. The extent of the healthcare information would include CPT codes and diagnostic codes. So if you have a patient name with some CPT codes and a little additional demographic information, you have information that's protected health information. And if it's been accessed in an unauthorized manner, then you have a potential breach. And the next step is really to conduct an analysis that the law requires to determine whether there was a low probability of harm to that information. Did that information get out, and was it accessed in an inappropriate manner? And are you just unable to mitigate any harm, or is it a exposure that is to such a degree that the information really is at risk? Another key issue is the entity is presumed, or I guess the incident is presumed to be a breach unless the entity demonstrates a low probability of harm. So the burden of proof is placed on the entity with regard to an incident. The first thing you want to do when you receive word that you've had an incident is what you probably normally do is contact your IT professional. And that should really be your first call, because your IT professional or the company that you use, they will be able to best deal with and identify the situation in an emergency context. Another thing you want to be aware of and talk to your IT company about is disconnecting from the internet, because really the goal of the contain component is, also preventing information from leaving your system. So if there's a hacker on your system, you want to be able to shut down that hacker's access and close the door to them being on your system. If there's ransomware on the system, we want to make sure that we can evidentially show that the protected health information that's on your server isn't being sent out into the internet to some unknown location. One of the ways we can provide evidence of that is by quickly closing that internet door so information can't leave the system. And then we want to protect your system internally. And one of the ways we do that is segmenting. We also want to be careful not to power down our systems if we can avoid it. Sometimes it's unavoidable, but as you see on this next slide, if you avoid turning off the system, sometimes we can preserve evidence that might be otherwise lost when you do power off the system and the short-term memory is erased. So the second component, once we close that door, is preserving the evidence immediately. Now, there's always a temptation to want to get up and running as quickly as possible, because the physicians, they want to treat patients. You make money by treating patients, but you really want to be careful not to just go ahead and wipe that system and try to rebuild immediately. The temptation's there, but what happens is you erase some of the evidence that you can use to show that information didn't leave your system. Also, we might be able to forensically prove that no one was on your system after all, and the virus that locked up your system wasn't the type that would exfiltrate data off your system. So even though you've had a ransomware incident, there's nothing, there was no medium or high probability of harm to that information, because there actually wasn't a hacker on the system and no information was lost. Some of the other items you can do is print logs, photograph if necessary. If you can't get around your system, use your cell phone and photograph the virus. And then you want to make sure your IT company is thoroughly documenting the incident. And you're going to also want to document the incident, but I put this IT company documentation here because we want to make sure everything on their side is documented, and to make it easier on the attorney in analyzing the incident. What are the obligations of the entity itself? Well, you have to investigate this incident yourself. You can't just rely on your IT company to do the investigation. You should have your privacy officer immediately identifying what's the scope of the EPHI affected. Did we have an encrypted EHR system that was HIPAA compliant, encrypted before we got hit with ransomware, or was the information unencrypted and now the ransomware has encrypted it and made it unreadable? How many patients were affected? And then with this information, you want to prepare a written incident report as your investigation is ongoing. You want to make it contemporaneous to your investigation and communication with your IT company. Other things to document are your computers and servers that were affected and segmented. You want to document what kind of antivirus software was in place before the incident, what kind of systems were in place before the incident to prevent ransomware. You also want to document the date and name of each person involved and what their role was in the investigation. So your IT people, or internally people who were involved in your practice. And we want to try to capture as much information about the virus with screenshots or printouts, and any other information we can document that would help us show if information was either left the server or didn't leave the server. The next step is really notify your insurance carrier, and once you have control of the situation, that really should be your next call, because you're contacting your carrier for emergency assistance, And getting a person in with specialized assistance, like an attorney, is very helpful. This is the first step in getting that person appointed. There also could be a coverage issue if you don't notify your carrier timely. So that's something you want to be aware of. And Kathy, I think this is an area you might speak to because it's on the TMLT side. Do you have anything to add?
Yes, as you said, there are reporting requirements, and with the cyber insurance that is embedded with all TMLT medical professional liability policies, you must report in 60 days in order to have coverage. So you don't want to delay. 60 days is a really long time, and there's lots of reasons you don't want to wait that long. But as Adrian said, the sooner you report, the sooner you get the resources available, such as an attorney to help walk you through the process of whether or not it is a breach that is reportable to the Office of Civil Rights, whether it's getting forensics involved, and all of these things that are coverages under your policy are important to get triggered as soon as you possibly can.
Perfect. Next, and this is really a tip for some practices, I always recommend the practices have a cheat sheet emergency response plan in place that their employees can reference, because sometimes your privacy and security officers just are not on site. So if you have a cheat sheet checklist, you do have a mechanism for your employees to work through the problem. And, the other thing you want to do is make sure you work through a scenario with your IT company. Don't just take your word for it. Work the IT company's word for it. Work through that response, the emergency response plan and checklist with your IT company. Ask them how they're going to segment the system if it gets hit with ransomware. Have them show you how they'll respond. Have them show you what kind of logs they'll document. And then work through the same issue with your employees. Have them show you how they're going to respond and document the incident. What is your plan going to be in place to make sure you're preserving evidence and containing and protecting the information? The next step, which we had spoken about briefly, was retaining an attorney with specialized HIPAA experience. And you do this as a TMLT insured just by notifying TMLT and having your cyber liability kick in. If for some reason you work at a practice that does not have cyber liability insurance, you want to make sure you have an attorney appointed who has actually represented practices before the Office of Civil Rights in HIPAA investigations. There are attorneys that have a lot of HIPAA experience but don't actually have the representation experience before these administrative bodies. That's really the key that you want to be looking for, is an experienced administrative law attorney. The next issue is you also want to refer back to your HIPAA policies and procedures after an incident. This is important because you need to follow your policies and procedures when responding to an incident. Oftentimes, you may have a set of forms and guidelines that you might need to fill out and follow. If for some reason you have to report the breach and provide information to an administrative body, they may ask you for, well, they certainly will ask you for your policies and procedures. So you want to know if you're following those actual policies and procedures as you work through your process. You'll also want to follow the templates that are in there if possible when you do perform your risk analysis of the incident. It's a continuity issue, and it looks better in front of the administrative body. It also helps your attorney identify any problems or issues that you might have. And you also may want to consider revising your policies and procedures in response to an incident. Kathy, do you have anything to add with regard to the policies and procedures?
Interestingly, this morning I was on a long phone call with a practice that had a breach about 10 months ago, and they've been working through their remediation, but they've had yet again a request from the OCR seeking more documentation and more clarification. And what it's really boiling down to for this practice is that their policies and procedures really just say what they should do. They don't really say how they are actually doing the requirements of the HIPAA security rule. And that's probably the one thing that we see a lot in post-breach mitigation or remediation is that policies and procedures that you buy off the internet or from resources often are just, this is what you should do, not, and they don't get specific about, in our practice, this is how we actually do policies and procedures, or how our processes work that meet that requirement. So I would say that's a proactive thing that every practice should be working on, is making sure their HIPAA security policies and procedures truly reflect how they do their day-to-day processes.
And that leads us into our next slide. The tip is really understand your policies and procedures and make sure they are drafted specifically tailored to your practice, and have a process-driven tailoring to them as well. I know there's a wonderful set of policies and procedures that TMLT offers, and Kathy can tell you more about those.
We do have a complete set of HIPAA policies and procedure templates that we drafted using the 2016 Office for Civil Rights audit protocol. They're very in-depth, and they take a lot. They do actually take quite a bit of time to actually work through and get all the details that the OCR is really looking for. But it's a great exercise for getting your practice up to date. If you have any interest in obtaining those, there's an email address at the end of the webinar, but it's simply consulting@tmlt.org. If you want more information, we can certainly provide that.
Yeah, and having a comprehensive set of policies and procedures is critical to an investigation, because one of the questions you'll always receive is, please provide a copy of your policies and procedures prior to the incident, and please provide a copy of your policies and procedures after the incident. So they're looking to understand, what did you have in place before the incident, and how did you modify it in response to the incident? And that would be with any administrative investigation from the Office of Civil Rights. The next tip, or I guess the next step in your process, will be the appointment of a forensic IT company to actually analyze your system and gather the evidentiary information and make a determination about the virus. We do rely heavily on specialized IT forensics knowledge and experience, and their opinions with regard to whether an incident is a reportable breach or not. And the determination that they're helping us make is whether there was a low probability of harm to the protected health information or not. And we're building the evidentiary case through the forensics to show that information did not leave the system, that it wasn't compromised beyond just the encryption itself, and that hackers weren't on the system, and that in their opinion there wasn't a compromise to that information. It's extremely helpful in the analysis. You also may consider notifying law enforcement. A lot of times a police report is very standard to make of an incident. If an incident involves ransomware or a hacker or some sort of virus, it is recommended that you report that to the it's called the IC3, but it's the FBI Internet Crime Complaint Center. You also may, in some cases, if it involves a financial crime like wire fraud, you might be contacting the Secret Service for assistance. Then you also have to keep in mind that if there's a drug diversion issue for some reason tied into your HIPAA issue, you might need to contact the DEA. There is the 24-hour rule if there is an actual drug diversion that you need to report. You need to report that incident to the DEA within 24 hours of discovery. And finally, if there's a breach of protected health information, you have to notify the Office of Civil Rights without undue delay and not more than 60 days after your discovery of the incident. And what they're saying there is without undue delay means it may be sooner depending on the severity of the breach, the information affected, and other information that is critical to a person's security. We do recommend practices avoid paying ransom demands if possible. This is a case-by-case basis, or a case-by-case analysis that we go through to determine whether the actual virus can be removed using either a pre-existing encryption key or through the help of another third party. Sometimes the practice is if they do not have an adequate backup, they are left with no choice but to pay the ransom and decrypt the information and hope that all the information can be decrypted and comes out okay. Sometimes it's just unavoidable, but for the most part, law enforcement and every healthcare entity would recommend that you try to avoid paying ransom demands. Next, as you go down the line, you want to arrange for a security rule risk assessment of your systems, and you really want to use an independent specialist to come in and analyze your systems. They call it triaging, identify how the virus or the hacker made it into your system, and implement corrective action to make sure we have closed all the doors that have let that virus or that hacker into the system. Also, the OCR, or the Office of Civil Rights, will ask for your most recent enterprise rule risk assessment, both before and after an incident. So having that done when you have a serious incident is really key and critical. And it's something I always recommend. If we can't get it done within 30 days, then we at least have it scheduled as soon as possible. And that leads into the next tip, which is to have an enterprise-wide risk management plan. And the risk management plan is your compilation of all the risks you've identified in your privacy and security rule risk assessment, also in your disaster planning. And this is actually a legal requirement that the U.S. Department of Health and Human Services would like you to have that plan written down and in place and updated periodically. If you have an incident, you're going to have to update that risk management plan following the incident, and they will ask for that updated plan as well. Kathy's worked on risk management plans to a great degree. Do you have anything to add, Kathy?
Just one thought there is that the OCR really does give you credit in investigations for things you have identified as issues, even if you have not fully resolved them, if you have a plan that you're working to resolve an issue. So that's where the risk management plan becomes important. And one other slightly unrelated thought, we're running a little long on time. We're going to keep going, but if anyone needs to drop off, I know some people have time restraints. The webinar is being recorded, and we'll make that available to you by email in the next 24 hours.
And The final thing we want to do, and we can start implementing this really as soon as possible, is corrective action. And part of our corrective action and mitigation is closing that door to information being able to leave our system. But we want to try to identify all of the vulnerabilities to our system and have them corrected as soon as possible and within 30 days. We also want to perform HIPAA training, update our HIPAA policies and procedures, get our risk assessment done or scheduled, and start updating our risk management plan. We also need to consider whether there's an appropriate sanction, and we need to take a look at some other things like our audit controls, our encryption technology, and our information system activity reviews to see what we need to update in response to this incident. And really, the process of corrective action, although it's going to take you longer than 48 hours to complete, it really begins immediately. I've provided a list of the regulatory agencies that are involved in investigations. I've seen most often it's going to be from the OCR, which is through the U.S. Department of Health and Human Services, and we are starting to see investigations out of the Texas Medical Board to a limited degree. This is an old sample letter that I received, a client of mine received from the Office of Civil Rights, and you can see highlighted below they're asking for all these issues in terms of the risk analysis, the risk management plan. They don't have policies and procedures listed in this, but they always ask for policies and procedures in their requests. And here it is. Actually, this is the second page to it. They're looking for a written response, your policies and procedures, the training you've completed, and your mitigation efforts and corrective action. There is a trend by the OCR to request significantly more information for ransomware incidents. These data requests for a ransomware incident probably are more like 20 to 30 questions at this point. And this slide is just a Texas Medical Board complaint related to a HIPAA incident that we received. I most recently dealt with a case from the Texas Medical Board that related to data loss from a server that failed, and the physician did not have a great backup solution, and the medical board dismissed the complaint because the physician had provided such significant corrective action and mitigation and was able to repopulate virtually all of the medical records by hunting down records from either paper or from other entities. So just to sum up, the first 48 hours after a cyber incident, you want to contain the problem, preserve the evidence, investigate immediately, document, and I can't stress that enough, document, notify your carrier, retain an attorney, and then understand your legal obligations, risk, and exposure.
Thanks, Adrian. That was a very informative presentation. Hopefully none of our participants are going to ever have to deal with a breach, but in today's environment, more likely than not, it's not a matter of if they will have a breach, but rather when. And certainly being prepared is going to make them much better, position them in a much better place for that investigation that's liable to occur. We are going to continue the webinar for a few more minutes and take questions. If you have questions following the webinar, they can always be sent to consulting@tmlt.org. We do have one question. It's a little vague, so the questioner might want to add some more details. But the question is, can you recommend a resource that might offer sample checklists and best practices on how to run a test? I'm thinking that's a test of compliance.
Yeah, I know that, yeah, I think one stop would be TMLT and the consulting that TMLT offers. You could also look to some of the other agencies. The Texas Medical Association has resources in this area. There's also the U.S. Department of Health and Human Services Office of Civil Rights has a fairly informative page or website that you can navigate through and try to find information to build your different checklists. Unfortunately, there's not necessarily a great one-stop shop that you can find online for free. But with a little bit of research and a little bit of investigation, you should be able to put one together pretty well. And if you wanted to have pay a consultant to come in, I know consultants absolutely can put together something for you, and they wouldn't hesitate to do it.
There is further clarification on this question, Adrian. It's the test is to test their response plan for a breach event.
I think I'm not aware of an independent consultant that does that, unless, Kathy, you may correct me, unless TMLT offers that service. I think it's a matter of, what we recommend is just a matter of working through the process with your own IT company to try to be prepared as best you can, because you never can really understand what will happen with your information and the problems that will be caused until a breach occurs. But if you can simulate it as best you can, then you can identify at least some of the changes you need to make that will better prepare you for that incident. But again, Kathy, you may have some more to add to this.
I don't, off the top of my head, have a readily available resource, but I will look for that, and I've got your name down, the questioner, and will certainly pass along any information I find. I agree with Adrian that it normally is done on a customized basis of presenting a scenario, and it can be as simple as handing your receptionist or whoever is the first person in the office on any given Monday morning a note that says, you cannot log into your computer, what do you do? And just start documenting what they do and what steps you actually work through from there. And your IT obviously is going to be a huge part of that.
Another consideration beyond the HIPAA component obviously is, how is the practice going to treat patients that day? We have patients showing up, but if we can't get into our scheduling calendar, how are we going to deal with that? That may prompt you to print your calendars for the week, the Friday before, and lock those calendars up so you have a printed list of patients who are scheduled to visit the practice the following week in the event that an incident occurs.
That's a real important point. Adrian and I had a case some time ago where the practice actually went about 2 months before they were able to get back into their practice management system. And so they didn't know from one day to the next what patient was going to walk in the door. So thinking through these scenarios, and I always tell people coming out of the hospital side, everybody had crash carts in the hospital. When we went to electronic medical records, we developed crash carts, which was really simply a file box with all the papers we needed to be able to go back to the paper processes of documenting, of ordering labs, all those types of things that we kept, and everyone knew where it was, that if somebody's section or the entire system went down, we could revert back to paper. And that's a good practice for practices, large and small. I'm not seeing any other questions. Again, I want to thank Adrian for his time and sharing his knowledge and expertise today. We would encourage you again to feel free to send us any follow-up questions at theconsulting@tmlt.org. And we hope you all join us again next month when our topic is an individual's right to access their medical records. There's a lot of new emphasis being placed by the federal government on this. Thanks everyone for joining.